Hello, I think we're all set and ready to go. Welcome everyone. Thanks for tuning in, spending your lunch hour with us today as we have the first in our series of webinars for small and growing businesses. Today, looking at legal considerations when starting a business. And before turning over to our speaker, Madelaine Thurston, just two quick things. First off, if you have questions, in your dialog box, from GoToWebinar, there should be a spot to be able to send in questions, and we'll get to those at the end of the presentation. And number two, if you want to download the slides, again, from the dialog box, you should be able to download a copy of today's slides. On past presentations, some people have struggled to do that. If you have any problems, just drop us an email and we'll happily follow up with a copy of the slides immediately after today's presentation. I'm going to turn things over to Madelaine Thurston, who is a lawyer in the business law group here at Kelly Santini. She advises business owners of all sizes on a wide range of legal issues, from the starting out incorporation of their businesses to shareholder agreements, commercial leases, contracts, mergers and acquisitions, and has worked with clients across a wide range of industries, including construction, real estate development, retail and leisure, medical professional corporations, insurance brokers, just to name a few. And so without any further ado, I'm going to get up, and Madelaine's going to take her spot and take you through these legal considerations for starting a business. Madelaine.
All right, so like Keith already said, my name is Madelaine Thurston, and I'll be discussing a couple of topics with you. So to start off, just going to have a quick outline of what we're going to be talking about. We're going to be talking about sole proprietorships, partnerships, including partnership agreements, corporations and the liability associated with those, how to figure out where to incorporate, how to name your company, shareholders agreement if you happen to have more than just yourself as the shareholder, choosing a business structure when it comes to picking between those three types, licenses and registrations, as well as quickly we'll talk about the IP considerations as well. So there are primarily three ways of carrying on business. You can do so by a sole proprietorship, by way of a partnership, which involves more than just one person, or a corporation. All right, so to start with the sole proprietorship, this is pretty simple. Doesn't necessarily require a lawyer for most part to be able to do, because it is so simple. You obviously can't have employees because you cannot be, or the owner, sorry, cannot be an employee because obviously you cannot employ yourself. And like I said, there are very few legal requirements to actually get this started. It's just pretty much starting up a business and doing that business under your own personal name. So in this case, if you're doing the business under your own name, you are obviously filing your taxes under the actual owner, which is yourself. So the profits and the losses are taxed in the owner's hands. If you are going to be doing a business under a certain name, which is not your own given name or your own legal name, then you would be registering a business name with the Ministry of Consumer Business Services. So if I'm running a nail salon and it's not being run under my name, then I would be registering a master business license for that. You would be, as part of that, also doing a search to make sure that the name is available. And there could be certain licenses to obtain under this, so depending on your governing body and how it is, and whether you need to get a license to be an insurance broker, you may need certain licenses and whatnot. So you'll have to look into the rules from the governing body to be able to make sure you've got those. So then we've got the advantages and disadvantages to this. So some of these I've already discussed, but just to summarize, obviously an advantage is that for a sole proprietorship is that it is quite easy to set up and to dissolve, because there's not really any documentation you would need to actually create it. With no documentation, it also means that it's inexpensive and there's few regulations. It could be beneficial, as you would be able to have direct benefits from the profits under your name personally. Disadvantages with this would be that there is no separate liability. You are going to be liable personally because the business is being run under you personally. Also means that you could have personal tax liabilities, and for obvious reasons, it's probably pretty difficult to raise capital, because who's going to wanted to provide capital to yourself without having some sort of reassurance or some sort of equity in that. Also, lack of continuity. This just applies because if you pass away or you stop the business, then it doesn't continue past that because it's directly tied to you personally. And also inflexible. So there are certain, when it comes to actually passing the business on, certain estate planning and ownership limitations that we'd be dealing with there because it's not a separate entity. Then we get into partnerships. So this has to do with doing business, and it's similar to a sole proprietorship, but there is more than one person. So like I said, 2 or more persons carrying on a business together with a view to make profit. So like I said, they're similar to sole proprietorships, and in this case, we would be calling all of the members of a partnership the actual partners, and they would be carrying on the business themselves directly. So once again, we're not necessarily going to be having corporations involved, although you could have corporations be partners in a partnership, but that's a further discussion. So right now we're just talking about the partners being the actual individuals. So in this case, the partnership is not a separate legal entity. Same thing as a sole proprietorship, the partners cannot be employees because the partners cannot employ themselves, although you can employ others. The partners are also going to be agents of one another, meaning that they have a certain duty of loyalty and good faith to each other. So you can't just screw over the other partner that you'd be working with. And once again, same as under a sole proprietorship, you'll be registering the name as well. Obviously, a partnership is going to have a name associated with it, and you would have to register that name under the Business Names Act. So similar to sole proprietorship, as if you were having a name that wasn't your legal given name. Once again, liability is going to be a problem here because you're going to have the same personal liability. In this case, you'd be sharing that liability with the other partners, so that may or may not be a good thing. And then for the taxation, each partner's respective share of income is combined with the other sources of income and taxed accordingly. So like a sole proprietorship, your income from the partnership is going to be part of your personal income taxes. So in summary, just having, once again, the advantages and disadvantages here. Once again, partnerships, pretty simple to create. There might be a little bit more documentation than a sole proprietorship, but still easy to create. Once again, inexpensive. There may be some tax advantages in regard to losses. And because you're in business with other people, you could share in the startup costs. There is also some limitation for liability because you'd be sharing that with the other partners. Some disadvantages is that sharing liability with other partners could make you liable for other partners' issues that may happen with them. So a disadvantage, in the same way as liability is an advantage, it could also be a disadvantage in this case. There's less flexible ownership than corporations. Once again, you're going to have the lack of kind of perpetual continuation from there because if you pass away, it's tied directly to you as a person, and possible conflicts with partners. Anytime you're going to get in business with more people than just yourself, there's always going to be a possibility of conflicts with partnership or even with a corporation as well. So the main document that a lawyer would normally prepare for a partnership would be the partnership agreement. So we would have a meeting with all the partners involved, and we'd sit down and discuss what kind of aspect we would like to have in the agreement. So we'll want to know what's the scope of the business activities, what kind of firm name you'd like to be using or business name you'd like to be using, and like I said, you'll want to register that business name. If there's any restrictions on carrying on competing business, so that would mean whether any of the partners are able to also act or also work on separate projects that are related to the business, or whether you want to make sure that all of their time is invested solely in the partnership. Requirements for admission of new partners, so we'll have clauses in regards to what is required to be able to accept a partner or also remove a partner if necessary. Taxation issues are going to be discussed in an agreement, as well as management and decision making. So I actually find the management and decision making usually the biggest, to see how decisions are going to be made. If there are only two partners, then normally we go with a unanimous, although if it cannot be unanimous, then you run into an issue of just no decisions being made. So we usually try to find a way of deciding how decisions are going to be made without getting stuck into a stalemate situation. If there's obviously an odd number, that's a lot easier to be able to do with a majority decision-making power. You're also going to come in to say how contributions are going to be made. So whether that's actual monetary contributions, or it could possibly be certain equipment that one of the partners is giving in, or certain services that that partner may have experience with. Those can all be different types of contribution that partners can put in. Also going to talk about dissolution. For one of the biggest dissolutions, if there's only ends up being one partner in the end, then it automatically is dissolved. But if we need to have some sort of agreement of when this partnership is going to last, if there's a time frame to it, if it's solely related specifically to a piece of property that it has to do with, then there's going to be a dissolution provision as well. And then the biggest thing, once again, is profit sharing. So discussing how the actual profits of the partnership are going to be split, whether they're going to be split equally, not equally, 70-30, 90-10, all these different types of profit sharing situations that you could have. Within the partnership aspect, there is also what we call limited partnerships. So this is when partners would come in and they are limited to the amount of capital that the partner actually provides. It is governed by the Limited Partnerships Act. And a limited partner is essentially a passive investor who generally shares profits in the proportion and contributions. So they're being passive. They may not be making any decision making. The general partner would be making the decision making, doing the decision making, or would be more involved with the day-to-day operation of the actual partnership, while limited partnerships are silent. So they come in, they give what money they need, they are choosing to give, and then share in the profits from there. Limited partnership agreements are similar to partnership agreements, but obviously have a little bit more substance to them, because we do have to limit the liability and have a couple more clauses on how those limited partners are going to be involved. Limited partners are only going to be responsible for what they've actually contributed to it, while general partner is going to be responsible or have the liability of all of the partnership. With this, there is a certain declaration that needs to be filed with the Ministry of Government Services, which that's what is required to be created. Usually a 1 or 2 pager documents, kind of fill in template form that's filled in and submitted over to them. And then we get into the biggest one. So this is normally the process that is used, and for most part, a lot of people do want to have the protection of having a separate legal entity as their corporation. So this is normally when lawyers will tend to be more involved. Like I said, a corporation is a separate legal entity, separate in law from its owner, so it's separate from the shareholders. It can own property, it can own bank accounts, it can own anything as if it were a person and carry on business. It also possesses rights and incurs liabilities. Like I said, corporations are the most common form of a business organization, especially with when lawyers are getting involved. So corporations can exist in perpetuity. So corporations aren't necessarily contingent on having the shareholders be alive, although there may be certain clauses in a shareholders agreement that we'll discuss later on what happens, but it can continue on in the future regardless of being alive or not. And the rights and the liabilities of the corporation are not always the same as the shareholders. Some advantages to this is that it's going to be a whole lot easier to be able to raise capital. So you're going to be either issuing certain shares, common shares, preferred shares over to the people who are raising capitals, or people that are providing that capital to the corporation. You may be doing shareholders loans. There's different types of ways to structure how that capital is being provided, but it's a lot easier to be able to get that into a corporation than it would to get it into a person. You're going to have limited liability. So like I said, in this case, the liability is with the actual corporation and not with the person or the shareholders involved. You've got flexibility of ownership, and then you've got taxation, which is going to be the corporation is going to be taxed as its own entity. Some disadvantages are the double taxation of dividends. You've also got a lot more record keeping that's going to be necessary. There may be annual returns that need to be filed with Industry Canada. You have minute books that need to continuously be updated every year. You've got registers that get updated with the officers and the directors, shareholders if you're transferring shares, issuing shares. So quite a few more documentation for the records that needs to be kept up, but that's what lawyers are for. And then the cost and formation of the organization. So in this case, normally you're going to be using a lawyer to do the articles of incorporation. So it's going to be a little bit more costly there. And not only would you be getting legal advice, we would also recommend getting accounting advice to see how to set up the structure to make sure that it's going to be the best for you tax-wise. So one aspect that you learn about in law school is the corporate veil. So the corporate veil is a protection to say that as long as the corporation and the people who run the corporation, so the directors and officers, are acting in good faith and doing what they are supposed to be doing in the best interest of the corporation, then you've got a corporate veil there that's going to protect the actual humans inside of it, being the directors and officers and shareholders. If there are some reasons where the corporate veil does need to be pierced, but this is more when things are done fraudulently or negligently, when the corporation, when it's decided that the corporation will pierce that corporate veil. So it's not very often. The whole point of a corporation is to have, or the biggest point is to have that liability excluded from you personally. Some other liability considerations is, in theory, liability of shareholders is limited to the value of shares they actually possess. So if you've got 2 shareholders in the company, you each have 50%, then in theory, you're only supposed to be responsible for that 50% ownership that you actually have in the equity of the company. Obviously, there are guarantees and whatnot that you as a shareholder may provide for the company that may alleviate the fact that you are limited to your shares depending on how that guarantee is working, which is what the next topic is talking about. So if you are getting a bank account for a brand new corporation, it is most likely the case that banks are actually going to ask for personal guarantees because the business is so new or the corporation is so new, it doesn't have any sort of credit history to be able to rely on. Same things with leases. There are a lot of the times the landlords are going to ask for guarantees from the shareholders personally because, like I said, there's no credit history to be able to rely on. We try to avoid those, but in certain situations, it's unavoidable. So, being a director of a corporation, you are exposed to some sort of liability because you are acting and you have a duty of loyalty to the corporation and you're acting in a certain way that's going to be in the best interest of the corporation and having profit made for the corporation, which means you're acting for the best interest of the shareholders. There may be certain examples like employee wages that there may be liability to the directors for. There is insurance that directors and officers can obtain, directors and officers liability insurance, which would protect them in case anything were to happen. And it's also, on top of that type of insurance, it's also good to have insurance for the business itself, for the commercial activities and whatnot, to ensure that the business is actually insured itself, and that would be the corporation being insured. And another aspect you want to consider is transferring personal assets prior to commencing the business. So certain situations, spouses starting a business may transfer, if the husband is starting a business, the husband might transfer his ownership in a matrimonial home directly to the wife, just in case the corporate veil is pierced for any reason. At least that way it would protect the matrimonial home from being seized by any creditor. So that's kind of it's very dependent on the situation of the people doing the incorporation, and that's a discussion that we would have with the accountants to decide what's the best way to be able to protect other assets that you may own. So then where to incorporate? So there are 2 ways to incorporate in Ontario. You can incorporate under the CBCA, which is the federal act, or you can incorporate under the provincial, which is the Ontario Business Corporations Act. There are pros and benefits to either way. So for the provincial one, the corporate name is a lot easier to be able to get accepted. The provincial governing body doesn't actually review the name the same way that the Industry Canada would review it. So there's a lot more options there if you're really concerned with having a certain name. They put the liability on the actual incorporator to be able to decide the name. So if you are being confused with another company, or you're picking a name that's already picked, it's more so in the person who's incorporating. It's their problem to have to deal with. Industry Canada or the Service Ontario isn't taking any ownership of that. It is slightly more expensive to incorporate provincially. At this point, I think it's $300 versus federal, which is only $200. Name protection is limited, so because they're not actually reviewing the name protected or the name chosen, they're not actually going to provide the same types of protection. And extra provincial licenses registrations are required. So if you are going to be registered in Ontario and you want to be practicing in Quebec or Manitoba and any other province, then you're going to want extra provincial licenses as well. And you've got restrictions on the location of the registered office. So if you're under the province of Ontario, you need to have a registered office within Ontario. Federally, like I said, the corporate names acceptance is a little bit more onerous because they are actually going to be reviewing that name. Annual returns need to be filed. So with provincial, there's no annual returns that need to be filed, although there is an option to file them if you want to. While with federal, they do need to be filed. And if you miss filing them for a couple of years, then you can be faced with an automatic dissolution of the corporation. The name is protected across Canada, which is why the onerous acceptance from Industry Canada is a little bit higher. It is a little bit cheaper to incorporate, like I said, just at $200. And then you also have the ability to carry on business all across Ontario. With this, you'll still need an extra provincial license to be able to do so, but it's a lot easier to be able to get those extra provincial licenses when you are incorporated federally. So when it comes to a name search, so we'll have clients come in and they'll either decide that they want to be using a numbered company, maybe because it's just going to act as a holding company and there isn't a requirement to have a name, or maybe they already have a master business license for a name and they'll just have a numbered company, 1234 Ontario Inc. operating as whatever name they've already been provided with, or they may want a specific name. So when we're doing that, we're always going to do a nuance search. And this nuance search will show us all names that are either the same or similar. They're going to talk about, it's going to refer to names that are maybe confusing or having unacceptable terms. One of the features of a name is that it always has to have a legal ending to it. Inc., Incorporated, Limited, Corp., whether it's short form or long form, always needs to be part of a corporate name. The cost for a nuance search is about $75 right now. So that's an additional cost, obviously, versus having a number where you don't have to do a nuance search and you can just file articles of incorporation and either Industry Canada or Service Ontario actually gives you the number. So you don't choose it, you fill in, leave that number blank, they give it back to you with a number filled in. On top of actually figuring out what name you want, you also need to figure out how we're going to structure the shares. So how many classes of common shares you'd like, how many classes of special shares, or whether you want any classes whatsoever. So these are the decisions that not only are discussed with your lawyer, but also with your accountant, because there may be certain tax decisions to be able to make from there. Normally, I would say for a pretty simple incorporation, we're going to be doing 3 Class A common and 3 separate preferred or special classes as well. So you got Class A, B, C of common, Class A, B, C of special. There's different attributes you can give to them, so you can decide which ones are going to have voting rights, which ones aren't. At least one of the classes of shares obviously has to have voting rights to be able to make decisions. You've got participation rights, deciding how dividends are going to be paid, whether dividends can be paid to just one class without paying them to another class. You've got redemption and retraction rights. So these are pretty much the same thing. Redemption rights is when the corporation is deciding to redeem the shares back, and retraction rights is when the shareholders are deciding that they want the corporation to retract the shares back. Got conversion as well as price adjustment. Price adjustment comes in more so with anything that's more of a tax plan transaction, where it has to do with you've decided what the fair market value of a certain transaction is going to be, and now CRA comes back and they've decided on a different price. So price adjustment clause allows you to deal with that. And then non-impairment, this is having to do with making sure that nothing's getting paid out on a class of shares into a shareholder without ensuring other liabilities can be paid. So it's not, you don't want to be paying shares over to all of the equity over to a class A common share, knowing that there's a redemption value on a preferred share that needs to be paid or needs to be calculated or included in that. One thing is we always try to not complicate the share attributes. They can always be changed in the future. So we can have 20 different classes of shares, but that just seems to be overcomplicated than what needs to happen, especially for a small business. You're just starting out. You're going to want to be as basic as what is needed. You don't necessarily need to have all these classes of shares that just aren't going to be issued in the end anyways. You can always add them on later on. There's obviously certain maintenance and annual filings that need to happen. So there is a requirement to have annual meetings for the shareholders. Obviously a lot easier if you're the only shareholder. You're just going to meet with yourself, so not that big of a deal. You've got approval of financial statements based on when the financial year end is going to be. So we should be having annual resolutions in the minute books for each year that the financial statements are done, which should be every year. Every year, you're also going to elect the directors, and this may or may not be the same director moving forward, or there may be other directors stepping in or stepping down. You're going to be appointing accountants or auditors, as well as exempting potentially from any audit requirements, which for most small businesses, you are usually exempt from audit requirements. You're also going to be appointing the officers. There are different officers we name. Usually the names we go with are president, secretary, treasurer. Although you'll see a variety of different names. They'll use CEO, CIO, all those different names. The naming itself doesn't truly matter. You can give whatever name you want, but normally we stick to president, secretary, treasurer to make it as clean as possible. You'll also be having resolutions in the minute book for declarations of dividends. So whether there's regular, eligible, capital stock, in-kind dividends, you've got a variety of different types there that are being issued. You're going to want to make sure that you've got the appropriate resolutions there. There's going to be annual returns. Like I said before, this is only for under federal. They can be registered or they can be filed for provincial, although it's not necessary as of yet. And then notice of changes. So if you're going to be changing the registered office, changing the directors at any point, then you're going to want to file notice of changes with Service Ontario or Industry Canada, depending on where you are incorporated. And then moving forward, as the business grows, there may be articles of amendment if you need to issue more classes of shares because you've got people coming in. If you want to amalgamate with another business, if you're closing down the business, you're going to do articles of dissolution or articles of continuance. This would be if you were registered under the OBCA, so under provincial legislation, and then you want to be moving your corporation over to Vancouver, then you would have to file articles of continuance with both jurisdictions to get that changed over. So part of a corporation, if you have more than just yourself as a shareholder, is to have a shareholders agreement. So this is the contract relating to the relationship between some or all of the shareholders. And it can deal with a number of different issues. You're going to talk about the voting rights, what material decisions need either unanimous or majority decisions to be made, how share transfers are going to work. And then once again, just like a partnership agreement, you can have restrictions on the competition between the shareholders. So whether they're actively involved or more passive, and whether you want them to be able to invest in similar companies or be involved with companies that have similar business, you can provide restrictions there. Other provisions you'd see in a shareholders agreement are going to be a shotgun clause, and these clauses mostly relate, at least the first three on that list, mostly relate to if things are going wrong between the shareholders. So a lot of times these aren't necessarily going to get used if everyone's happy, business is going great. Shotgun clause is used when that relationship starts to deteriorate, and this allows shareholders to be able to get out of the actual or stop being shareholders of that corporation, but allows them to get paid most likely the fair market value or what they've been offered. So a shotgun clause is one of those. Right of first refusal, if one of the shareholders would like to have their shares sold to a third party, they would first have to offer them to the other shareholders that are already shareholders in that company. You've got piggyback rights, which is if one of the majority shareholders, let's say, is choosing to decide to sell their company to a third party, that the minority shareholder would be able to piggyback on and be able to sell their shares for the same value that the majority shareholder is selling them for. There's also tag-along rights or drag-along rights, another word for those. So the drag-along ones would be where you can force a minority shareholder to sell the shares the same way you are doing so. We also going to talk about the death and disability of shareholders to say, well, how long does one need to be incapable to consider them disabled? What happens with the shares if one of them passes away, whether it goes to their estate, whether the other shareholders have the right to buy the shares out, or different scenarios there. And then also protection from Family Law Act provisions as well. So if there is a dissolution or a breakdown of marriage while you're a shareholder, we'll have certain clauses to say how there's going to be protection for the other shareholders there, so they're not potentially dealing with the ex-spouse. So when it comes to choosing a business structure, there's a lot of different things to consider. You're going to want to think what's legally allowed, how you want liability to be structured, whether you're okay with taking on the liability personally or whether you want to put that into a corporation, how you want the existence to move forward, if you're okay with it kind of ceasing to exist once you pass away, or whether you'd like it to move forward for children or have some sort of succession planning there. Also estate planning. I also do estate planning, so happy to answer questions about that separately from this to say how to structure that succession planning moving forward. Also depends on the number of owners you're going to have involved there, and then the relationship between the owners will have a part of deciding which structure is going to work best for you. Other considerations would be the cost of how much it's going to cost to be able to incorporate versus doing a partnership agreement. Moving forward, it may, as you're expanding the business, there may be some employee participation to think about there, to whether you want to give them options for shares, and that will most likely be further discussed in further webinars. You've got citizenship requirements. There is requirements for directors to be Canadian citizens, or a certain percentage of the directors to be Canadian citizens. Flexibility of the structure, and then taxation. And taxation is going to be best dealt with your accountant as well. So it is possible to switch between the different structures. Obviously, you might start off as a sole proprietor because the business is on the smaller side. You want to eliminate costs. And as you grow, it's decided that a corporation makes more sense. So there is ways of transferring it over and having the assets transferred over to the corporation, and different tax transactions that happen there. The same way that we can also change a company from a provincial to a federal, which, like I mentioned before, you can do articles of continuance. Not only can you move from province to province, but you can move from provincial to federal if it makes more sense as the business is expanding. You're going to want to consider business name registration in all of this. So you want to make sure if you want a specific name for the corporation that's available. There may be assignment of contracts as well, because if you've got contracts with independent contractors under your name personally, you're now assigning those over to a corporation as you grow. We're going to have to look at the assignment clause and ensure that either it's doable or that we can get the prior written consent that may be necessary. And once again, liability and taxation are going to be considered on whether it makes sense to move it over to a corporation. So for licenses and registrations, like I said at the beginning, we've got the business name registrations that you'll need to consider. One part of this is if I've got a company and it's Madelaine Thurston Inc., and I choose to run my company just under Madelaine Thurston, now I do need a business name registration, because if you're going to lose that legal element at the end, you need a registration to it. So that's one of the biggest factors I find a lot of people may not be aware of, that if you are going to lose that Inc. or that Corp at the end, that you do need a master business license for it. Other things that you may want to consider as the business grows is Ontario Employer Health Tax, WSIB, Insurance Board, things like that. You'll also want to be getting certain business numbers from CRA, depending on your GST and HST situation, also payroll deductions. So those numbers are pretty easy to be able to get from CRA. Normally just give them a call and they'll give you the required numbers that you're applying for. There's certain licenses that would be needed for certain industries. Same thing for a sole proprietor. If you're an insurance broker, there is going to be a license that you'll need to apply for, and in this case, the corporation would be the one applying for it. City bylaws to follow, and in this case, most registrations can actually be done online. CRA is usually the most difficult company or industry to be able to deal with. They don't really have much that you could do online when it comes to getting registrations, but a quick call to them usually suffices. And one of the last things I wanted to discuss, or second last thing I should say, is the intellectual property. So if you're going to be preparing a certain trademark for a company, you've got a certain logo you want to work with, then you're going to want to make sure you protect those. So we've got 3 different types of intellectual properties. There's patents, which is the right to exclude others from making or using an actual invention. You've got trademarks, which is a registered name, a symbol, a logo. It's a way of identifying the product and is legally restricted to the use of the owner, all registered with the appropriate governing bodies. And then you also have copyright. So this is protection of expression of ideas in certain literary, musical, dramatic, or artistic works. Most of the time as a corporate lawyer, I'm going to be dealing with trademarks and making sure those trademarks are registered. I do not specifically practice in the area of IP. I've got the general knowledge to be able to know what it is, but a lot of times we'll be referring you to an IP specialist to make sure that if you've got a trademark that you want to get protected, that it's being registered properly. And then the last piece is non-disclosure agreements. So non-disclosure agreements can be used for multiple different reasons, and they can provide different types of protection. So non-disclosure agreements you may have with employees or for independent contractors that work for the corporation to protect the confidentiality or trade secrets that are used within your business. Like I said, they can be used for employees to make sure they're not providing any leakage of that information. The other reason non-disclosure agreements can be used is if you are acquiring a business, then you may not want that, at the beginning stages at least, you may not want that acquisition to be public knowledge. So you'll have an NDA signed by the parties involved to ensure that nothing is released to the employees of the company that you are buying, so that they can find a reason to quit if they're not happy about it. So it's to protect the confidentiality mostly of mergers and acquisitions in that case. So that's the end of my presentation or my webinar. There are further webinars, and you'll see some information about those in regards to growing businesses, hiring your first employees, as well as best practices in preventing and managing litigious issues with small businesses that'll be done in the future.
Thank you, Madelaine. It's taking us through a lot of different issues, and we're going to certainly give everybody a chance to submit any questions right now if they want to pose anything to Madelaine. We'll wait and see what comes in. You mentioned during your talk that you don't have to start off as an incorporated company. You could start off as a sole proprietor, then perhaps take on a partner. Is there a sort of a tipping point when a company, a business would know, yeah, we're ready, we should make the leap and now get into and go and incorporate?
It's hard to know exactly when that leap is. As a lawyer, I'm going to say incorporate right off the bat, because that avoids any liability moving forward. If something happens and you end up getting sued when you're a sole proprietorship, that already happened. You can't go back and incorporate to fix that. So I'm always going to say that incorporating right off the bat is the best. It's easier to be able to, and probably cheaper to be able to incorporate while everything's fresh and while everything is on the basic level, versus trying to incorporate at a later point when now assets need to be transferred. Accountants need to be a little bit more involved in regards to how to get those assets into a corporation. So it is more work to do it in the future, although it is still possible. So I'd say right off the bat is probably even the best choice.
Okay. Question on annual returns. You mentioned during, if you're incorporated, there's ongoing requirements. What is actually included in an annual return?
It's not a complex document. It's a one-pager. It just confirms when the shareholders had their meeting. It confirms the directors are still the same, confirms the registered office is still the same. It's, like I said, just a one-pager, gets signed by the director, whoever is the signing officer for the company, and then gets filed. So with Industry Canada, they do have a way of providing you with notifications when they're due, because for obvious reasons, people tend to forget. So they usually, about 3 months before the due date, they do send an email. It's an automatic email to say, look, this is going to be done within the time period. And that's how normally they get done, is with those reminders.
Okay, thanks. 2 questions about partnerships. The first one, when partners start off before they're incorporated, are they automatically considered to be equal, or even at that stage can they be have different levels of equity, for lack of a better word?
If you aren't going to have an agreement in place, then it can be assumed that they're going to be equal partners. But the partnership agreement is what's going to assist in if they aren't going to be equal. So if you're not going to have any documentation, then probably safe to assume that it's going to be equal. But as soon as you've got a partnership agreement, that's going to state how much capital each one's putting in and how they're going to share the profits. So a partnership agreement would be necessary pretty much in all circumstances to be able to at least decide how decision making is going to happen. But if it's not going to be equal partners, then it's even more necessary.
Okay. And partners have to have a name, registered name?
Yes, they do.
So we can't set up Gallup and Thurston?
No, we would have to register that name. Okay. Yes.
And one more question on limited partnerships that you mentioned. If you have a limited partner who's invested and then they're a silent partner, do they still have liability issues?
They would only be liable for the amount that they've actually put in. So their liability would be limited to the actual contributions they put into the partnership.
Great. Well, thank you, Madelaine. Thank you, everyone who's tuned in. And I'm sure if you do have additional questions, Madelaine would be more than happy to answer those for you. Her details are on the screen there, email and telephone number. And yeah, next webinar coming up, Legal Considerations for Growing Businesses. That's October 8th and going to be presented by Mike Deluisio. He'll be looking at things such as taking out a commercial lease for the first time, developing your commercial contracts, further issues on more enhanced shareholder agreements. So tune in for that. Details for that and registration can be found on the homepage of the Kelly Santini website. Following that is Brett Croswell presenting on hiring your first employee in the complex world of employment law in Ontario and making sure that you take care of all the details that are required for that. Thank you again, everyone, for tuning in. And again, if you weren't able to download the slides and would like a copy, just drop us an email and we'll follow up. And wish you all a very good day. Thanks. Bye-bye.